Okay, hello everyone. Now we begin the presentation. I give the moderator Batuhan Baytaz. Batuhan, you
Thank
can
you, Professor
begin.
Sözer.
Okay.
Welcome everyone again. And now we're going to have a session, and the topic will be COVID-19 and the course of the England and Wales. And the speakers is Dr. Edward Johnston. But first of all, Dr. Rahime Erbaş will introduce Dr. Edward Johnston. Okay, Rahime, it's your turn.
Thank you so much, Batuhan. Edward Johnston is now senior lecturer in law and at the University of West of England in Bristol, and now is responsible for leading and teaching a number of different modules across the LLB provision. He is the module leader of the both criminal procedure and punishment, also very focused on organized crime and criminal justice. He's also the program leader for criminology and law. His research interests center on adversarialism, the role of defense lawyer, defense right, and defense disclosure. Also, he completed his PhD in 2018 with title Defense Lawyer in the Modern Era. This study based on empirical research which examines the role of the defense lawyer. Also now he is at Routledge Publishing House. He's the chief of criminal justice series. So that's what I would like to express regarding Edward Johnston. Okay, your microphone is yours, Edward.
Thank you, Rahime. Good morning, everybody. I'm here this morning to talk to you about the rise in virtual courts and its potential impact for trial by jury in England, in Wales. Got an opening thought for you. The jury trials are underused. They have no place in modern criminal procedure, and we should therefore abolish them. This has been a government goal for the last 25, 30 years in trying to curtail the use of jury trials. And as I walk through my presentation this morning, I will hopefully be able to paint a picture in terms of why they are underused and how the global pandemic has accelerated the use of virtual courts, and that implication for both fair trial rights for the defendant and juror engagement during trials. So as we move through this presentation, this is a statement that I would like you to think about and to keep in your mind, that there is an implicit goal to curtail the right to trial by jury. So what is the classic view of the jury trial in England and Wales? Well, it's a fundamental key to democracy. Lord Devlin's famous speech in his book Trial by Jury in the mid-1950s said that trial by jury is more than an instrument of justice, more than one wheel of the Constitution. It is the lamp that shows that freedom lives. This, for many sort of criminal procedure scholars over the last sort of 50 years, has been the focal point of how important jury trials are in England and Wales, that they are the lamp that shows the freedom lives, and it is a key to our democratic process. So we've had jury trials for centuries. How do we make a jury today? Well, they're selected at random, as you well know, and the goal of this composition is to be socially representative, i.e. that you are charged with a criminal offence, excuse me, you are charged with a criminal offence, and therefore you should be judged by your peers, people like your neighbours, people who you work with, your friends, all the people from your social circle. It's that idea that your peers are representative of you. Many years ago, up until the 1970s, this used to be tied to a property qualification, i.e. to sit on a jury, you had to own your own home. So that's your first curtailment of the right to a trial by jury. Many people in England and Wales do not own their own home, but without owning your own home, you couldn't sit on a jury. That was amended in 1974 by the Juries Act. And what they used was the electoral register as the source to draw all the jurors from. Now, there's a further problem with that. If you look at any general election in England over the last 30, 40, 50 years, roughly about 55 to 60% of the population vote. So there are many people who are not registered to vote, many people who do not care for politics, but they won't be eligible for jury service. So again, we are saying that we select all these people from random, that they are a jury of your peers, and yet we are narrowing the focus of where we can pick these people from. It's problematic because we have a vast issue with BAME groups not being represented on juries, yet being overly represented in the dock. So it's problematic there. Take up of jury service. So once you are selected for jury service, you don't necessarily sit, you can get out of it, as it were. I was selected for jury service during when the criminal courts first returned after the global pandemic in June, when we reopened our courts in England and Wales. I was selected, but because everything was reduced, I was later told that I'm no longer needed for jury service, but that will count as my, you're only generally going to be selected once for jury service, and that will count as my selection. I probably in the rest of my life won't be selected again. Data on take-up is relatively sort of scarce. There isn't a great deal of figures on this, but if we go back to 1999, between June and July, there was roughly 50,000 people summoned to sit on jury service, but Ayres and Shaw found the take-up rate was very, very low. The vast majority of people were deferring or getting out of jury service. So in 2001, Lord Justice Auld was tasked with analysing the criminal justice process of England and Wales, sort of every single facet of that process. And when he centred on juries, he found that we are being deprived of the skill and experience of a wide range of professional and otherwise successful people and busy people. There were a number of people who couldn't sit on a jury because of their employment, solicitors, lawyers, police officers, for example. Lord Justice Auld changed that. He allowed those people to sit on a jury trial, and his proposals were accepted by Schedule 321 and Schedule 33 of the Criminal Justice Act 2003. And this had an immediate positive impact. The rate of jurors actually serving and not deferring their service increased somewhere between sort of 52 to 64%. So a small increase, but an increase nevertheless. And what we then allowed, because of the Criminal Justice Act, was for police officers, prison officers, solicitors, people in the armed forces, pretty much any profession, unless you've been sent to prison for a prescribed period of time, or you have mental health concerns, that means you've been sectioned under the Mental Health Act. But by and large, almost every profession is now eligible to sit on a jury, and I welcome that. I think that's a good approach. There are some issues with jury service that I'll come on to, but I think this is a good approach. So, do we now have full representation? Still, sadly not. We still have many from BAME groups who are underrepresented on juries. So people of colour, different ethnic origins, they are not as represented as white British citizens. So I said the take-up increased. So we have some statistics from 2015 that said sort of over 360,000 jury summons was issued throughout the calendar year, but the number who actually sat on the jury was just roughly 180,000. So that's a take-up rate of under 50%. So when we said that under the Criminal Justice Act of 2003, we had a brief spike of around 64-65%. That now has fallen back down to around 50%. So the problems that we had before the old review in terms of take-up are replicated nowadays. There is an issue that, you know, 1 in 2 people will not sit on a jury. So basically, all of this means that your chances of serving on a jury as an ordinary citizen to try your peers are relatively slim. The Ministry of Justice have declined to give figures on your percentage likelihood of being summoned for jury service, but a BBC Scotland report found that the probability of being asked to serve is just around 40% over a person's lifetime. So it's not very high. So what we have are issues with underrepresentation. It's underused. So is this worth keeping? Is the provision of juries worth keeping? And then when we come in a moment to look at virtual courts during the pandemic, I think that asks the question of whether or not we should move from jury service in a physical courtroom to either virtual juries or just having a judge hearing a case alone. That is the push in England and Wales. We have had the Victims Commissioner, Vera Baird, suggest that for cases involving a complaint of rape, that a jury shouldn't hear that case at all. Conviction rates are very low in England and Wales for rape cases and serious sexual assault. So the Victims Commissioner would like to remove juries from that offence. That's something that I can't necessarily agree with. I think if we start changing our procedure for tailoring to certain offences, I think that's a slippery slope, and there will be other offences that would follow suit with that. And I don't necessarily think that satisfies the right to a fair trial under Article 6. I don't think conviction rates alone should be the measuring stick of whether or not something is successful. But to return to this question, are juries worth keeping? Well, generally speaking, in England and Wales, there's roughly 2 million prosecutions each year, 75% for summary-only offences. So that means 75% of them will be heard in the magistrates' courts. They're summary only. You can only be in prison for up to 6 months for these offences. No jury will be involved in this case. The rest are either way offences where the defendant can elect to sit either in the magistrates' court or in the Crown Court, or indictable only offences, which because of their severity means you can only have your case heard in the Crown Court. Over 80% of the defendants who have either way offences elect to choose the magistrates' courts. So they don't want to have a jury hear their case. And I guess, and this is a guess, is because the sentencing powers of the court are limited. So you can only be in prison for up to 6 months as a maximum for the most severe case that you would have in the magistrates' court. Approximately 96% of all defendants are exclusively dealt with in the magistrates' courts. So that leaves us 4% of this 2 million cases that will be heard by a jury. So what we have is this sort of traditional provision of justice, but only 4% of cases in England and Wales actually go in front of a jury. Now, the reason for that is because if you elect to have a jury trial but you enter a guilty plea before your trial starts, the jury doesn't hear anything. So it's a small number of cases each year that actually go in front of a jury. So it's little used. So what's the big deal about it? Well, the big deal basically is that it is the cornerstone of an adversarial system. This idea that you are judged by your peers. Why is that important? Because jury equity is the primary advantage of having a jury. So what does this mean? It means that where the state has brought a charge against the defendant, the jury will acquit the defendant where it sees the defendant has been prosecuted unfairly. That's how it works in theory. So if the jury sit there, they hear the case and they believe that, well, this evidence doesn't necessarily stack up. This is a form of unfairness. They can return a not guilty verdict and the defendant will walk free. However, there have been many cases of miscarriages of justice in England and Wales, especially during the early 1990s, the Winchester 5, the Birmingham 6, the Guildford 4, all of them involving sort of IRA terror attacks in England. And despite the fact that there was flimsy at best evidence, I think is the best way to describe it, the jury still convicted these people. So it isn't necessarily this foolproof defense where things are looking unfair. The jury might not notice this unfairness. So in these IRA cases, the jury did not know of the fabricated evidence, the suppressed evidence, the oppression in the police interrogation stage. So this idea that the jury will acquit where a defendant's unfairly prosecuted, in reality, doesn't really play out that way. And again, it's the same point, but written in a different way. If they sympathize with defendants, they can acquit them. If the law is unfair, they can acquit them. Now that in England and Wales has been a little bit more advantageous. So we haven't had any convictions of assisted suicide because the jury thought it would be unfair for those charged with helping a loved one to end their life to be unpopular or felt sorry for them. So using jury equity, despite the fact the case will stack up evidentially that the evidence produced at court would be beyond reasonable doubt, the jury can still say, no, I don't want to convict here. So they don't. So jury equity, whilst problematic, does have its advantages. The jury verdict is sacrosanct. This is another huge advantage to jury trials. What does this mean? Well, sacrosanct means something that is regarded as too important or too valuable to be interfered with. So basically, the jury decision cannot be interfered with, regardless of the verdict they return. And I think that's good, but I also think that there's some problems with it. So basically, you cannot penetrate this verdict. Is this desirable? And when I give this lecture to my students, I use the analogy that, well, people should have to explain their reasons. So is there a course for some juror reform to show how they reach their verdict? Because we don't know what happens in the juror room. We have 12 people sat there deliberating probably a week's worth of evidence, if not longer than that. And then 12 separate people will reach this verdict. Now, I'm sure we all understand how groups of people work together. There's not going to be 12 individual voices. You probably splinter it off into smaller factions. There could be one booming, domineering, controlling voice driving that decision. So when we say that this verdict is of 12 people, I don't actually believe that. And I'm carrying out some research with a colleague at Birmingham University at the moment that looks into juror decision making. How do people reach these goals? And what we found initially is that they are driven by the loudest voice in the room. So we think that 12 people have convicted or acquitted this person, but that number is going to be far fewer in reality, because people fall in line with domineering voices. That's human nature. But to return to this idea of we cannot penetrate this verdict, I don't think that's a sound notion in this day and age. So I say to my students, if you hand in a piece of coursework to me, I mark it and I tell you it's gone through the deliberating process of moderation, but all I return to you is your mark of 65%. How does that help you? You know, how do you know that I've marked it correctly? Because I haven't made any comments. All I'm returning is this mark. And that's akin to a jury. All we see is their final score, guilty, not guilty. That's it. We don't see anything else. So I think there is a case to answer in terms of we should see transparently how the jury have reached their verdict. I think that would increase fairness. It would slow the system down, albeit, which is something the government doesn't want the criminal justice system to do. But I think we should see their verdicts. And for me, that's the biggest flaw with juries, okay? That we can't see what they say. So why are jury trials important, despite the fact that only 4% of all defendants are going to see a jury? But I'm sat here in England, you guys are sat there in Istanbul, listening to why juries are important for a small number of cases. Well, they provide a system of checks and balances, so we can check state power to ensure it's not being misused. Tied into that is, would they prevent tyranny? Okay, so just because someone in power doesn't like a certain sect of people, they can't prosecute them for no reason. Keeps everything in order. In theory, they should represent the voice of the people in the criminal justice process. If there's something going on in your area, you should be able to transparently go into court. And if you are called as a juror to serve on this case, you administer your version of justice, okay? But again, people don't take this up, and we don't see how they arrive at this decision. Jury equity, as I've just explained, is very important. You know, we can balance things out if we feel sorry for people or feel like something's unfair. But all of this is transparent. We have ordinary lay people within this process, and that's a benefit, an absolute benefit. These aren't magistrates sitting alone. They're not judges sitting alone. Everyday, ordinary people make decisions in the criminal justice process. We've covered the state interference, and there's secrecy. So you can talk in the juror room extremely freely without knowing that you don't have to explain anything, that you don't have to, you won't be questioned on how you made your decision. Jury should be impartial. They have no vested interest in this case. They are not prosecuting the defendant. They are not defending the defendant. They have no interest in this case other than to find the fact of whether or not this defendant is guilty or innocent. And tied into secrecy and impartiality, everything is private. So my question is that if virtual courts or virtual trials impact these advantages, is it worth it? And in a moment, we will see the impact of virtual courts. But I want to continue with some disadvantages of juries. I said at the outset that there are issues with juries, that I think there are things we can make better. So what are the disadvantages? Well, you have no legal knowledge, okay? Right off the bat, you do not need to be legally trained in England and Wales to sit on a jury. You do not need to hold a law degree or go to university or even have A-levels or a school level education. None of that is required. Can the ordinary person exclude the media representations and media coverage of criminal trials? I think this is very difficult in high profile cases. I would question how well people can do that. You know, the media influences everything that we think about and everything that we hold dear. So I wonder just how well we can exclude media coverage that might prejudice the fairness of a trial. Generally speaking, in England and Wales, we can't vet jurors, okay? So in America, I don't know if you watched The Staircase with David Rudolph, but that case, for 3 months, all they did at the start of the trial was pick jurors. And it went on so long that the judge had to pick the jurors in the end. But in England and Wales, we're not really allowed to vet potential jurors to kind of identify what benefits they would bring for either side of the case. Are ordinary people misled by lawyers' techniques as to the strength of evidence, the eloquence or education or intellect of a lawyer? Will that colour what somebody thinks about the facts laid before them? What do we do? I said at the start that there's no legal training. So what do we do with people who might have an insufficient intellect? You know, can everybody follow complicated cases? We'll have you sat there for 4, 5, 6 hours a day following complex legal argument that doesn't flow in a straight line. It weaves like a meandering river. So can the everyday person be trusted to comprehend everything that that they've heard, and therefore to consider what they've heard and come to a fair and just decision? I'll show you in a second why I think that's problematic. Boredom. I'm sure all the students in this room right now have been at one stage or another bored by listening to someone talk for 2 hours, 3 hours, 4 hours. But the fact is, you're enrolled on a law program, you have an interest in law. If you're an ordinary person, just an ordinary citizen, without any interest in law or current affairs, what's going to happen if you get bored? You switch off. So we said at the start that there's 12 random people here, but all 12 might not be listening all the way through the trial. Costs. Anything that you read about criminal procedure in England and Wales over the last 20 years will be driven by economy. Crown Court trials are far more expensive than those heard in the Magistrates' Court. So the Crown Court is where you would have a jury trial. The Magistrates' Court is just a magistrate sitting alone. They are about 4 or 5 times more expensive than magistrates' cases. So there is a great desire to reduce these costs in the criminal justice budget. Therefore, virtual courts will be even cheaper than magistrates' courts or jury trials. So should this be a driving factor in our decision-making processes? Should we prioritise economic savings over fairness? And that is the big question in England and Wales that simply isn't being asked right now. What we hear is virtual courts work, we like them, and they're likely here to stay. And I think if we have virtual courts, I think what we'll see eventually is a further curtailment of jury trials as well. You'll have them in the first instance virtually, but I do think we will look to move away from jury trials. There was one suggestion, again, I keep returning to this idea that jury trials are trying to be curtailed in England and Wales. Well, one suggestion by a government minister suggested that prolific criminals should lose the right to jury trials. So if you have 20 previous offences, you should lose the right to a jury trial. I have an issue with that. The vast majority of people who are sentenced and found guilty in England and Wales have a raft of previous offences. Over the summer, I've just finished writing my second textbook, and I looked into this for a section on sentencing. And I found that 39% of all defendants sentenced in the Crown Court have somewhere between 30 and 65 previous offences. Okay, so what prison's doing is nothing. Okay, we're not deterring people from crime. So if prolific criminals should lose their right to a jury, is that fair? Fundamentally, for me, the answer would be no. Just because you have 39 previous offences, it does not stack up to say that you have committed the faultier. It may give an indication as to your bad character, but I don't think that we should punish you before you are actually convicted. And therefore, I think prolific criminals should have the right to elect juries. And that's something the government accepted a couple of years ago. Controversy. So I've painted this picture that I'm kind of torn on the adequacy of juries. I like them. They are a due process safeguard that's really beneficial in any society, but they return controversial decisions. And as a lawyer, I sometimes struggle with this. The first case I'm going to give you is the case of Crown in Ponting. Now, Clive Ponting was a man who was a civil servant in the Ministry of Defence. As part of his position, he had to sign the Official Secrets Act, which basically means, as you can probably guess, anything that he sees or hears, he cannot divulge to the public. Okay, so any of his information needs to be redacted, can't disclose it, etc., etc. During the early 1980s, Great Britain was at war with Argentina over the Falkland Islands, and the British Navy sank a cruise liner called the Belgrano. Now, the common story that was perpetuated by the armed forces, the government, and then the media was that the cruise liner, the Belgrano, was sailing into British-controlled waters on the coast of the Falkland Islands and would not turn away. Clive Ponting saw an official report that basically indicated that the Belgrano was sailing to the British Navy. The Navy warned them to turn around, otherwise we would open fire. The Belgrano accepted this warning and turned around to leave British waters. It was then fired upon by the British Navy. The cruise liner sunk. Everyone on board died, but the British public wasn't told that particular state of affairs. So Clive Ponting saw this and thought, well, this is too important to not be told to everybody. People need to know this. So he took this evidence to his MP, who asked an open question in the Houses of Parliament about this very issue, and Ponting was then arrested and charged because he breached the Official Secrets Act. Now, the breaching of the Official Secrets Act is a strict liability offence, and what we mean by that is there is no defence to breaching the Act. You either breach it and you're convicted, or you didn't breach it and you're not convicted. Ponting never claimed he didn't breach it. He accepted he breached the Act. So the judge directed the jury at the end of the case to convict Clive Ponting. Now, if you follow the letter of the law, that's the right approach. But jury equity comes into this here, and Ponting was acquitted. The jury sympathised with Ponting, thought he did the right thing. He breached the Act, knowing full well that if he was caught, he was likely being sent to prison for a long time. He disclosed this information because he believed it was to be in the public interest. The principle of jury equity returned a not guilty verdict, and Ponting could not be convicted. He was acquitted, which I think shows the strengths and the weaknesses of juries in one fell swoop, really. You either want certainty with law, or you want this idea that cases can be nullified by us, the ordinary person, sympathising with jurors. The second case I want to talk to you about today is a far more controversial case. It's the case of Stephen Young. Stephen Young was charged with a double homicide of an elderly couple in a cottage in Essex, just outside of London. After a long trial, the jury couldn't reach their verdict. So after a number of hours of deliberations, they couldn't reach their verdict. So what the judge said is, right, I'm going to sequester you into a hotel. You will go away and think about your case and deliberate in due course. So what happened was that on night one, you're in a hotel, it was all expenses paid. A number of the jurors got together and started drinking from the minibar. After a number of alcoholic drinks, all of them were drunk by now. After a number of alcoholic drinks, one of these jurors said, let's get a Ouija board out and let's ask the dead people if Stephen Young killed them. So they did. They sat down with a Ouija board and they asked the question of whether or not Stephen Young was guilty of this particular offence. And the Ouija board spelled out, vote guilty tomorrow. So at breakfast the next morning, they convinced the other jurors to vote guilty. They returned to court, delivered their guilty verdict, and within about 20 minutes, half an hour, one juror started feeling a little bit uneasy at how they've arrived at this decision and told the court clerk, this is how they've arrived at this decision. They've got drunk and used the Ouija board. So the judge finds out, quashes the conviction, orders a retrial, and Stephen Young is eventually convicted of this double homicide in a second trial. But the point of that is can we trust ordinary citizens to deliver fair and just verdicts? On one hand, you have Ponting, clearly guilty, but the decision is nullified. On the other hand, you have Stephen Young, where juries aren't taking their responsibilities seriously, and it's worrying. It's a worrying conclusion. Further issues with jurors, if they are directed by the judge to follow something to the letter, can they do it? Well, Cheryl Thomas is pretty much the only academic at the moment that's looked at whether or not jurors understand what they're asked to do. And this is a self-reporting study. So what you have is the majority of people thinking that the decisions are either extremely easy or easy to understand. But because it's a self-reporting study, you have a difficulty with the idea that maybe people won't admit to finding something difficult. So we have to take this with a grain of salt, really, because people might not be telling the truth. But there is an issue, because 15% are based at number 4 and even lower at number 5, but people are finding it difficult or extremely difficult to understand. So if they're finding it difficult to understand, who are the best ages that understand juror directions? Now, I ask this question to my students every year, and normally they say my age, someone around the mid-30s to early 40s. They're the best people that can understand decision-making processes. They're not. It's the younger people, 18 to 29. 49% of that category understood the directions better. And I think that's to do with the fact that, schooling goes on much longer nowadays, university, college, etc., etc. So people are used to following complex arguments. So the younger you are on a jury, the more likely it is that you will understand what's being said to you. So what did Thomas find? Well, she found that most jurors thought the judge's legal instructions were easy to understand, but a majority, in fact, did not completely understand them in the terms used by the judge. So understanding the complex language. A written summary of the legal directions given to the jurors during the judge's oral directions improved comprehension. So it's easier to listen and then read than just listening alone. As I've just shown you, younger jurors had the highest level of comprehension. Almost half the jurors did not feel that they would know what to do about improper conduct. So if you have an issue like the Stephen Young case, almost half of the jurors surveyed didn't know what to do about that. That's a worry. A majority of jurors wanted more information about how to conduct deliberations. You're pretty much left to your own devices, so they don't know how to conduct them fairly. Almost all jurors supported the existing rule of requiring things to remain secret. So that's not really a surprise. So that's a real snapshot of juries in England and Wales, how we have them, how we use them, some of the issues with them. What I want to think about now is this idea of virtual courts in juries. Is it a quicker fix? Is it a better fix? I've based this around the pandemic of COVID-19, but it's important to remember that since 2003, excuse me, since 2003, we have had virtual or remote hearings. Now, Section 56 of the Criminal Justice Act 2003 allows for a live television link or other arrangements by which a witness, while somewhere in the UK but outside the court, is able to see and hear a person involved in the proceedings. So what these are basically for, generally they're for remote hearings in terms of bail. We've not had full trials until the COVID-19 outbreak. But that's something the government has been pushing for the last 10 years. Technology-driven justice. So we've had the ability to have some portion of the hearing done virtually for almost 20 years, but it's rarely used. So what happened when COVID-19 exploded everywhere? Well, the first thing that happened at the start of the outbreak, or start of the lockdown in March, was the government said there'll be no new criminal trials if they were longer than 3 days. So if your trial was longer than 3 days, it would be postponed to the end of the pandemic. However, this was quickly amended because people were falling ill, both lawyers, solicitors, jurors. So all trials were postponed. And here is the biggest problem and the biggest cause for concern in terms of trying to prioritize efficiency and economy. This added to the vast backlog of cases faced by the criminal justice system of England and Wales. At the end of March, so pretty much at the start of our lockdown in England, the backlog was 326,000 cases still outstanding. By the end of June, this rose to over 500,000 cases. And what we're finding now are cases of someone being arrested and charged 18 months ago won't still have a trial until 2022 because of this backlog. So we are trying to push the use of virtual courts to ensure these cases are dealt with quicker, to alleviate this backlog. But I just wonder if you can just take a moment to think of any issues or problems with the use of virtual courts. I just think that, are there issues, or should we just push along with this? I'm going to address some of them now, and I've split them down into different settings. So in practice, practical concerns with virtual courts: the lack of proximity. The jury does not see the defendant face to face. Okay, so what do you have there? Well, do you build any kind of rapport with the person that you might be sending to prison for the rest of your life if they are on the screen? If we take today's example of this lecture, the proximity is problematic here. There would be various points at this lecture where I would stop and ask the students, what do you think of this? You can see where I've highlighted that on these slides, but I'm unable to do that because we're not face to face. And if we are struggling in a lecturer-student capacity, surely the jury must feel some sort of proximate distance between the defendant. And I just wonder how important that is. Psychologically, it's easier to do something negative when someone isn't physically present. So you have to give someone bad news. What's the best way to do it? Do you want to give that them to their face, or would you rather do it over the phone or a live link? So there is an ease of finding a difficult decision that will vastly or greatly impact someone's life by not being physically present. So that proximate distance is problematic. This is a lawyer talking here. I prefer the defendant to be on video link when I defended. I always sought to have the defendant present in court, so the judge or magistrates would have to refuse bail to their face. So again, it's that idea of not seeing someone and giving them bad news. What the magistrates think of this? Well, unsurprisingly, they think it's fine. In my experience, prison to court video links, so when someone's in the prison looking for a remand hearing or a pre-trial hearing, links have enabled defendants to participate in the same way as if they were in court. They have not been disadvantaged nor advantaged. It results in fewer delays due to vans being caught in traffic or the incorrect prisoner paperwork being given. That is not a surprising approach from the judiciary, in all honesty. But what I am flabbergasted to believe that someone doesn't think that there is a disadvantage to not being present in the courtroom when your liberty is at stake. So what other practical issues do we have? Well, a police officer thinks there's long delays in trials. So, waiting around to give evidence, it's easier to give it over a video link. I accept that, but I think that those efficiency drivers come at a great cost. There is poor video and audio quality with this technology. It is not perfect. Tristan Kirk of the Evening Standard, he's the court reporter for a major London newspaper, tweeted of an August hearing that lasted for 12 minutes. The defendant was on the video link and says he can just hear typing and a distant voice of a judge. And then the judge turned around and said, well, can you hear me now? There was only one working microphone in the court, so the judges and all the barristers ended up being huddled around the same microphone. And at the end, the defendant could say he followed it vaguely. If we can't get the technology correct, I can't see how this process can be fair. Okay, if someone can only vaguely follow the proceedings that could send them to prison, arguably for the rest of their life, or potentially for the rest of their life, I think there's a massive issue here. And what else happens with these issues, not necessarily practical issues, but from the lawyer-client relationship, the defense lawyer is viewed as the zealous advocate for the defendant. He's his shield against the oppressive state. But there is a breakdown in communication between links between defense lawyers and defendants. With these links, frustration builds and frustration rises. Defendants become more agitated. There were elements of, examples of defendants becoming so frustrated at the use of virtual courts, they began swearing at the technology, saying F this and F that. And that's not something you would ordinarily see in the courtroom. The defendant cannot understand the emotion invested by the lawyer. Generally speaking, lawyers will meet their clients on the morning of the trial, not before that. Barristers will meet them on the morning of their trial. Barristers get emotionally involved, where they sympathize, empathize, or zealously go to bat for the defendant. But the defendant cannot experience this emotional positive through a video screen. Defendants generally distrust lawyers, especially defense lawyers, despite the fact that they are their adversarial shield, they are their friend, they are the person who is looking to advance their best interest. There is a distinct lack of trust between defendants and lawyers and defense lawyers. They view them as part of the all of one same machine. But this lack of trust is amplified by not being present in the same room, not being sat closely next to each other. Sharing of documents or information, if the defendant doesn't understand something, They could whisper from the dock to the defence lawyer's bench for a bit of clarity, but that's obviously impossible via video link. The court hearing itself, does the defendant understand and follow exactly what's happening? I've just said that they can't clarify things. By not being unable to understand issues, defendants are often seen shouting at the screen, and some are more aggressive than what they would normally be, which obviously, if you're aggressive or someone's deciding your fate, that's a negative. Okay, there might be things being read into that aggressive outburst at your frustration at the technology. So this is from Transform Justice, a leading criminal justice charity in England and Wales, and it asks one basic question: what is the positive or negative impact of video hearings on the defendant's ability to participate in the proceedings against them? The defendant has a right to participation, but as you can see, 58% of people surveyed found it had a negative impact on participation, with only 11% of defendants thinking that video link was positive. So the vast majority of people think that this is not a positive tool. What is the positive or negative impact on video hearings on the defendant's ability to communicate with both practitioner and judges? So all of those points that I had outlined 2 slides ago are manifested here with a 72% negative rate. Okay, I think it's highly negative. The only benefit I can see from virtual courts or virtual trials is that it's quicker and it saves money. What it doesn't do is deliver justice. And I think until we start tackling the fundamental problem of the criminal justice system, is that it needs to be just, and justice isn't always cheap. I don't think we can get away from that. And I think that's going to be a problem moving forward. I've just got one final slide for you here. What do I think the future of virtual courts when we're out of the pandemic going to be? I think there's a desire for virtual courts to become the norm in England and Wales. And when you couple this desire with maybe the poor performance of some juries, i.e. the Stephen Young case, the inconsistent decisions made in the Clive Ponting case, I think couple that with this desire, and I think we will radically see jurors being used less frequently in England and Wales. It will start with rape or terrorism, and then it will be a slow drip to eventually disband juries under the auspice of economy. Because the attraction of efficiency and economy is being prioritized over the effectiveness of the product being used. Virtual courts are not effective. They're not effective for defendants. And I believe that the defendant should be the focal point of the trial. It's his liberty that's at stake. It's his career, his family that he may lose if he's convicted. So I don't think that they are fair. Covid-19 has allowed the government to run a pilot of virtual courts. This has been going on for pretty much since July, late July. And what you find, if you follow any criminal justice practitioners on Twitter, their own anecdotal examples of things not going well is basically the upshot. If defendants have these issues in terms of the technology, why won't juries? How do they build rapport or read the body language of defendants and witnesses if they can't see their whole body, if they're not physically in the room? I mentioned boredom earlier in the talk, and I wonder if, will it be easier to get bored if you're just watching a camera? Is it easier to switch off if people can't see you? These issues need to be teased out. I'm looking to put a bid in with a colleague that's looking at the practical impact of virtual courts. We're just about to submit it to UKRI, so hopefully we'll have some news soon. Juries are juries an essential element to justice? By having virtual courts, we could clear the way to abolishing or reducing juries once and for all. And it might not sound like a big deal because only 4% of cases reach juries, but I still think fundamentally it's really important. Overall, I think COVID-19 and the acceleration of virtual courts present a real threat to the fairness of proceedings, and ought to be abolished in favour of opening up closed courtrooms to ensure the backlog of cases can be cleared. Over the last 10 years, we've lost about 50 courtrooms in England and Wales, where the buildings have either been just purely closed or they've been closed and sold off to private enterprises. I think if we open up or build more courtrooms, that will clear the backlog, but obviously the money is problematic there. I want to thank you all for listening. I hope you've enjoyed the talk and found it useful. Thank you very much.